Good morning to all of you. I hope all of you are doing good and all of you are great. So let's start today's discussion. Today we are planning to discuss MP Civil Judge 2018 Shift 2 question paper, as well as we are going to discuss MP Civil Judge 2017 question paper. And today we are going to discuss some of the questions from CRPC, that is Criminal Procedure Code, then from Negotiable Instrument Act, then from Constitution, and then from some of the questions from CPC. So अगर अभी तक आप लोगों ने हमारे चैनल को लाइक नहीं किया है, सब्सक्राइब नहीं किया है, तो प्लीज डोंट फॉरगेट टू सब्सक्राइब एंड डोंट फॉरगेट टू लाइक द वीडियो. And if you want to enroll for MP Civil Judge Prelims, link is in the description box. Do check it out. In this particular segment, you are getting 10 plus mocks, recorded video lectures, and much more. So let's start today's discussion. Now, question number 101, that is from Criminal Procedure Code. All hospitals, public or private, shall provide first aid and medical treatment free of cost to the victim of offense of acid attack and rape. This particular provision of CRPC is contained in which a provision? Option A, section 357B of CRPC. Option B, section 357C of CRPC. Option C, section 357A of CRPC. And option D, section 53A clause 2 of CRPC. So question number 101 is simply asking that all the hospital, whether public sector or private, shall provide free first aid and medical treatment to all the victim of rape and all the victim of acid attack. So this particular provision is contained in CRPC in which section? Option A, 357B. Option B, section 357C. Option C, section 357A. And option D, section 53A subclause 2. So its correct answer is section 357C of CRPC. Yes, Vinny ji, you are correct. Next question. Question number 102. Who among the following is not entitled to claim maintenance under section 125 of CRPC, Criminal Procedure Code? So which among the following is not entitled to claim maintenance under section 125 of Criminal Procedure Code? Option A, wife living in adultery. Option B, major married daughter who cannot maintain herself. Option C, both husband and wife living separately by mutual consent. And D, all of these or all of the above. So the options are wife living in adultery, then option B, major married daughter who cannot maintain herself. Option C, both husband and wife living separately by mutual consent. And D, all of these or all of the above. So who among the following is not entitled to claim maintenance under section 125 of CRPC? Yes, Vinny ji, its correct answer is D. Ankita Gupta ji, its correct answer will be D for Delhi. That is all of the above. It means the wife living in adultery, major married daughter, and the husband and wife who cannot maintain herself, all of these people are unable to claim for maintenance under section 125 of CRPC. Question number 103. When can a trial court release an accused on bail under section 389 clause 3 of CRPC after conviction? So they are asking when an accused person can be released on bail after conviction. Option A, when accused is on bail and the imprisonment is not exceeding 3 years. Option B, where accused is on bail and imprisonment is not exceeding 5 years. Option C, when accused is on bail and the imprisonment is not exceeding 4 years. And option D, where accused is on bail and the imprisonment is not exceeding 2 years. So what should be the correct answer? If you will read section 389 clause 3 of CRPC, it is simply stated over there. Okay, so this is a direct question from their act. So question number 103, what should be the correct answer? Yes, its correct answer will be A for Ahmedabad, that is where the accused is on bail and imprisonment is not exceeding 3 years, right? Next question, question number 104, that is who can withdraw a case from the prosecution under section 321 of CRPC? So which of the following is authorized to withdraw a case from prosecution under section 321 of CRPC? Option A, the state government. Option B, public prosecutor in charge of a case with the permission of the court. Option C, public prosecutor in charge of a case even without the permission of the court. And option D, district magistrate. So which of the following person, you can say that which of the following is authorized to withdraw a case? So state government, public prosecutor in charge of a case with the permission of court, public prosecutor in charge of a case without the permission of the court, and the last one is district magistrate. So its correct answer is B for Bangalore, that is public prosecutor in charge of a case with the permission of court. Next question, question number 105. Now, under section 357A clause 2 of criminal procedure code, which of the authority is authorized to decide quantum of compensation? Which of the following authorities like having the authority to decide the quantum of compensation? Option A, session judge. Option B, legal service authority. Option C, chief judicial magistrate. Option D, district magistrate. What should be the correct answer? Question number 105. Yes, Varunji, B for Bangalore is the correct answer. That is legal service authority. Now, if you people will follow up section 357A clause 2 of CRPC, it is providing two types of legal service authority, that is state legal service authority and district legal service authority. So B for Bangalore is the correct answer. Now, next question, question number 106. Now, this is the question from your Negotiable Instrument Act, which is stating, I promise to pay B rupees 500 and all other sums which shall be due to him. This is a which type of document or which type of instrument as per Negotiable Instrument Act? Option A, promissory note. Option B, bill of exchange. Option C, an ambiguous instrument under section 17. And option D, none of these or none of the above. Question number 106. What should be the correct answer? Yes, 105. Yes, Vinny ji, Ankita ji, both of you are correct. B is the correct answer. Question number 106. So, I promise to pay rupees 500 and all other sum which shall be due to him. This is a which type of document? So we can simply say that this is a none of these or none of the above. Now, if you people will be having idea, if suppose there is a statement that I promise to pay rupees 500 to B, then it can be considered as, definitely it can be considered as promissory note. Okay, but moving further, they have added another clause, all other sum due to him. So if this particular clause is there which has been marked in red, it simply means it cannot be considered as promissory note. Neither it is a bills of exchange. Okay, and ambiguous document bhi nahi hai if you will read section 17. So its correct answer will be D for Delhi. Next question, question number 107. That is, now, under section 138 of Negotiable Instrument Act, complaint may be made within dash from cause of action arise. So they are asking number of days. So under section 138 of Negotiable Instrument Act, complaint may be made within dash days from the date of cause of action arise. Option A, 15 days. Option B, 1 month. Option C, 45 days. And option D, 2 months. What should be the correct answer? 107. Yes. 15 days, 1 month, 45 days, 2 months. What should be the correct answer? Question number 107. Question number 107. Its correct answer will be your 1 month, right? Its correct answer is 1 month, right? From the date of cause of action arise, that is from 1 month, right? Now, both of you, Varunji and Viniji, are saying its answer should be C, that is 45 days. But as per the official answer key of MP High Court, its answer is B for Bangalore, that is 1 month. Next question, question number 108. Under offences under Negotiable Instrument Act are compoundable. Option A, under section 145 of Negotiable Instrument Act. Option B, under section 147 of Negotiable Instrument Act. Option C, under section 142 of Negotiable Instrument Act. And option D, under section 320 of CRPC, Criminal Procedure Code. The offences are compoundable under which section of your the offences are under Negotiable Instrument Act are compoundable under which section? 145, 147, 142, 320. Yes, 108. What should be the correct answer? So its correct answer is B for Bangalore. That is under section 147 of Negotiable Instrument Act. The offences are compoundable. Right? Chaliye. Let's move towards next question. Now, question number 109. Now, in a prosecution under section 138 of Negotiable Instrument Act 1881, it shall not be a defense that option A, the check does not bear his signature. Option B, that the check was not issued for the discharge of any debt or other liability. Option C, that the check has not been presented to bank within a period of 6 months from the date on which drawn or from the period of its validity, whichever is earlier. Option D, that the drawer had no reason to believe when he issued the check that the check may be dishonored on presentment. Here, if you people can see, so they are asking which of the following shall not be a defense. Shall not be a defense. So question number 109. Yes, Viniji, D is the correct answer. That is, the drawer has no reason to believe when he issued the check that the check may be dishonored on its presentment. Question number 110. Offences under Negotiable Instrument Act are triable by option A, session judge, option B, judicial magistrate of first class, option C, executive magistrate, and option D, judicial magistrate of second class. So offences under Negotiable Instrument Act are triable by session judge, judicial magistrate of first class, executive magistrate, and judicial magistrate of second class. What should be the correct answer? Yes. This question is quite straight. If you people can relate it, offences under Negotiable Instrument Act are triable by session judge, judicial magistrate of first class, judicial magistrate of second class, and executive magistrate. So its correct answer is B for Bangalore. That is judicial magistrate of first class. Chaliye ji. So this is how we have completed another question paper of 2018. Shift 2. Now we are going to move MP Judicial Services Prelims examination of 2017. This particular examination conducted only in one shift, right? So the first question is from Constitution of India. Now this is going to be interesting for all of you. The first question is from Constitution of India. The question is, the mind of makers of Constitution of India is reflected in which of the following? When the Constitution of India was drafted, so what was the reason behind drafting such constitution? The mind of the makers was reflected where? Option 1, preamble. Option B, fundamental rights. Option C, DPSP or directive principle of state policy. And option 4, that is fundamental duties. So what should be the correct answer? Preamble, fundamental rights, directive principle of state policy, and fundamental duties. Where we can see the mind of the makers of Constitution of India. So its correct answer is first, that is preamble. Next question. Who is ex-officio chairman of the state? This is again a very straight question. Who is ex-officio chairman of the states? Option 1, president. Option 2, vice president. Option 3, prime minister. And option 4, speaker of House of People. So president, vice president, prime minister, speaker of House of People. Which of the following, like who is the ex-officio chairman of Council of State? So this is quite easy question. You people would have studied in polity as well. Okay. This is particular thing is defined under your Article 64. Article 64 gives the answer, that is second ka second is the correct answer. 2 is the correct answer, that is vice president. Yes, Vinny ji, Ankita ji, both of you are correct. Next question. All doubts and disputes arising out of or in connection with election of president shall be inquired into and decided by. all the doubts and disputes arising out of in connection with election of president shall be inquired into and decided by option 1 Prime Minister, option 2 Council of Ministers, option 3 Supreme Court of India, and option 4 Election Commission. Prime Minister, Council of Ministers, Supreme Court of India, and Election Commission. What should be the correct answer? Yes, Prime Minister, Council of Ministers, Supreme Court of India, and Election Commission. Yes, Vinny ji is saying third ka 3. Yes, 3 ka 3 is the correct answer. That is Supreme Court of India. So Ankita ji, you are correct. Vinny ji, you are correct. Now, next question. Question number 4. Right to property is a. Right to property is a. Option 1, fundamental right. Option 2, legal right. Option 3, social right. And option 4, directive principle of state policy. So, right to property is which kind of right? It is like fundamental right, legal right, social right, and directive principle of state policy. So, what should be the correct answer? Fourth question ka. Fourth ka, yes, second is the correct answer. In the case of Vishambar Sharma versus State of UP, Supreme Court of India held. याद रखिएगा केस का नाम विशंबर शर्मा वर्सेस स्टेट ऑफ यूपी. द सुप्रीम कोर्ट ऑफ इंडिया हेल्ड that right to property is basically is nothing more than a legal right. It is not a fundamental right. Next question, fourth ka, yes, Vinny ji, Ankita ji, all of you are correct. Second, B is the correct answer. Question number 5. The words unity and integrity of nation were incorporated in the preamble of Indian Constitution by which of the following amendment? 41st Amendment, 43rd Amendment, 42nd Amendment, and 44th Amendment. Yes. So, fifth question, what should be the correct answer? By which of the following amendment we have added the word, that is particularly 41st Amendment, 43rd Amendment, 42nd Amendment, and 44th Amendment. Now, fifth ka second is the correct answer, that is 42nd Amendment. If any one of you are getting confused between these option numbers, third and second, so these are shuffled. So those who have marked 42nd Amendment, all of them are correct, right? Now, next question. Who administers oath of president? Which of the following person is authorized to administer oath of president? Option 1, Chief Justice of India. Option 2, the Election Commissioner of India. Option 3, Vice President of India. And option 4, there is no need to administer oath. Which of the following person administers the oath of President of India? First, Chief Justice of India. Second, Chief Election Commissioner of India. Sixth ka first. Yes, sixth ka first is the correct answer. Varun ji. Yes. Ankita Gupta ji, no, its answer will not be fourth D. Its correct answer will be first. If you will read Article 60, so it is simply stating that the Chief Justice of India is going to administer the oath of President of India. Vinny ji, Varun ji, both of you are correct. Question number 7. A money bill can be originated. A money bill can be originated. Option 1, only in Lok Sabha. Option 2, only in Rajya Sabha. Option 3, in both houses simultaneously. Option 4, at a joint sitting of both of the houses. Question number 7. A money bill can be originated only in Lok Sabha, only in Rajya Sabha, in both houses simultaneously, and fourth, at the joint session of both houses. So 7th ka, yes, first is the correct answer, Vinny ji, that is only in Lok Sabha, right? Money bill can be originated only in Lok Sabha. Yes, Ankita ji, you are also correct. Varun ji, its answer will not be not Rajya Sabha. Money bill is originated only in Lok Sabha under Article 109 Clause 1 of Indian Constitution. Money bill can be originated only in Lok Sabha, not in Rajya Sabha, right? Chaliye, question number 8. By operation of which article of Indian Constitution the law declared by Supreme Court shall be binding on all the courts within the territory of India? So, by the operation of which particular article of Indian Constitution, the law declared by Supreme Court shall be binding on all the courts within the territory of India. This is your question number 8. So options are Article 140, Article 141, Article 142, and Article 143. What should be the correct answer? Yes, Viniji, under Article 141. That is second option. It simply states that all the laws declared by Supreme Court shall be binding on all the courts in India. Right? Next question. Question number 9. Who shall preside the joint sitting of both houses of parliament? Who shall preside the joint sitting of both houses of parliament? First, Deputy Chairman of Council of State. Second, Speaker of House of People. Third, Vice President of India. And fourth, President of India. So, who shall preside the joint sitting of both houses of parliament? Deputy Chairman of Council of States, Speaker of House of People, Vice President of India, and fourth, President of India. So, its correct answer is Speaker of House of People. Ninth ka second is the correct answer. So, if you will read your Article 118 Clause 4, there it is simply stated that the Speaker of House of People, right, that is the Speaker of Lok Sabha, is going to preside the joint sitting of both the houses of parliament, right? Next question, question number 10, that is, in which one of the following case it was held that smoking in public place is violation of fundamental rights of life and personal liberty? Option 1, Mohini Jain versus State of Karnataka. Option 2, Murli S. Deora versus Union of India and others. Option 3, Prem Shankar Shukla versus Delhi administration. And option 4, Shankari Prasad versus Union of India. 10th ka, yes, Varunji, second is the correct answer. That is Murli S. Deora versus Union of India. In this particular case, it was held that smoking at a public place is violation of fundamental right. Okay, Article 21. Yes, Viniji, Ankita ji, all of you are correct. Question number 11. That is first question from your C.P.C, Code of Civil Procedure 1908. A suit filed for compensation for a wrong done to a person or movable property shall be instituted in the court within whose jurisdiction? Within whose jurisdiction? Option 1, where the wrong was done. Option 2, the defendant resides. Option 3, the defendant personally works for gain. And 4, any of the rest 3 option. So its correct answer is 4th. 11th ka 4th is the correct answer. Yes, Viniji, Varunji, both of you are correct. If you will read your section 19 of C.P.C, you will come to know that its correct answer is that at any of the place the suit can be filed. Question number 12. In a suit against central government, the authority to be named as defendant is option 1, President. Option 2, Prime Minister. Option 3, Minister of the concerned department. And option 4, Union of India. Yes, Ankita ji, you are also correct. 11th ka 4th is the correct answer. Question number 12. In the suit against central government, the authority has to be named as President, Prime Minister, Minister of the concerned department, and the Union of India. So its correct answer is 4th, that is Union of India. Yes, this particular question, like if you will read your section 79, section 80, you will get the answer of this question. Next question, question number 13. In an execution proceeding, what is the liability of the legal representative of the deceased judgment debtor? Remember that they are asking the liability of deceased judgment debtor. First, he is under no liability at all. Option 2, he is liable only to the extent of property received by him from the deceased judgment debtor. Option 3, has absolute liability coextensive with that of judgment debtor, no matter that he receives no property from the deceased. And 4th, none of the above or none of these. So what should be the correct answer? Yes, 13th ka second is the correct answer. That is the liability only to the extent of property received by him from the deceased judgment debtor. So 13, Yes, Vinny ji, Varun ji, both of you are correct. Ankita ji, you are also correct. Next question. No permission to sue as an indigent can be granted if option 1, application does not disclose cause of action. Option 2, any person has agreed to finance the litigation. Option 3, the interest of the applicant in the subject matter stands transferred to another. And option 4, all of these or all of the above. So, if you people will read Order 33, Rule 5, you will be in the position to find the answer that no permission to sue as an indigent person can be granted if first the application does not disclose cause of action. Second, any person has agreed to finance the litigation. Third, the interest of the applicant in the subject matter stands transferred to another. And D, all of these. Question number 14. 14 का 4 is the correct answer. Yes, Ankita ji, Vinny ji, both of you are correct. Now, next question. Question number 15. Attachment of portion of salary can be continued for a maximum period of. Attachment of portion of salary can be continued for a maximum period of. Yes, Varun ji, 14th ka 4 is the correct answer. Option 1, 6 months. Option 2, 12 months. Option 3, 24 months. And option D, 36 months. So, for which time period, maximum time period, the salary of a person can be attached? Question number 15. If you will read section 60 clause 1 of C.P.C, you will get the answer of this particular question. Yes, question number 15. 15th ka 3 is the correct answer. That is the maximum period for which the salary can be attached for 24 months. Now, once the salary has been attached for 24 months, then it will be requiring a break. Okay? Remember this thing. The maximum period for which the salary can be attached is of 24 months. It's not 12 months, Varun ji and Ankita ji. 15th ka 3 is the correct answer. Now, next question. Question number 16. Under which of the following conditions a plaint cannot be rejected? Under which of the following condition a plaint cannot be rejected? Option 1, if fails to disclose cause of action. Now remember, they are asking plaint cannot be rejected, right? First is if it fails to disclose a cause of action. Option 2, if it is not filed in duplicate. Option 3, the plaintiff fails to comply with the provision of Order 7, Rule 9 of C.P.C. Option 4, if it is filed in a court of incompetent jurisdiction. So, this particular question is from your Order 7, right? Order 7 is talking about, Order 7, Rule 11 is talking about your rejection of plaint. So, which of the following cannot be a ground of rejection of plaint? Yes, Vinny ji, for 16th ka 4 is the correct answer. That is, if it is filed in a court of incompetent jurisdiction, then the plaint will be returned. Then the plaint will be returned to be filed in a competent court of competent jurisdiction, right? So yes, Ankita ji, Vinny ji, both of you are correct. Question number 17. Which of the following statement is correct? Which of the following statement is incorrect? Sorry, which of the following statement is incorrect? First, temporary injunctions may be granted only at the time of institution of suit. Option 2, temporary injunctions may be granted at any stage of suit. Option 3, temporary injunctions are regulated by Code of Civil Procedure 1908. Option 4, temporary injunctions are form of preventive relief. So, which of the following is incorrect about temporary injunction? Now, if you will read Order 39 of C.P.C, you will be in the position to find that its correct answer is first. Yes, Varun ji, you are correct. Vinny ji, you are also correct. So, temporary injunctions may be granted only at the time of institution of suit. This statement is incorrect because injunction can be granted, temporary injunction can be granted and at any stage. An ex parte decree can be set aside under Order 9, Rule 10, Order 9, Rule 7, Order 9, Rule 13, and Order 9, Rule 11. Yes, Ankita Gupta ji, 17th ka first is the correct answer. An ex parte decree can be set aside under Order 9, Rule 10, Order 9, Rule 7, Order 9, Rule 13, and Order 9, Rule 11. Yes, Varun ji, 18th ka 3 is the correct answer. That is Order 9, Rule 13. Yes, Vinny ji, you are also correct. Now, let's move towards next question. Under section 100 of CPC, second appeal lies to the High Court from every decree passed in appeal by any subordinate court to the High Court if it involves option 1, question of law, option 2, question of fact, option 3, mixed question of fact and law, option 4, a substantial question of law. So, under section 100 of Code of Civil Procedure, CPC, second appeal lies to High Court from every decree passed in appeal by any subordinate court to High Court if it involves question of law, substantial question of law, question of fact. Yes, Vinny ji, its correct answer is 4. That is substantial question of law. Now here I would like to tell you a very important thing. You people can just hear it and can write it somewhere. If you want to file first appeal, that should involve a question of law. Second appeal should have a substantial question of law. And appeal to the High Court should have a substantial question of law with general importance, right? So here, even though they haven't added the word general importance, but they may add another word, a substantial question of law having general importance, okay? And the High Court thinks that the matter should be decided by Supreme Court. Then in that case, that particular matter will be decided by Supreme Court, right? Question number 20. Pleading shall contain first, material fact only, second, only law, 3, facts and law both, and 4th, evidence. What should be the correct answer? So, which of the following things should be contained in the pleading? Material fact, only law, facts and law both, and evidence. Material fact, only law, fact and law both, and 4th, evidence. Yes. Ankita Gupta ji saying 20 ka C. Nahi Ankita ji, its answer will not be C. Varun ji, Vinny ji, you are correct. If you will read Order 6, Rule 2, it is stating that material fact only should be contained in the pleading. So its correct answer is 1, right? So now, see you people in the next class by tomorrow. Meanwhile, if you people have attended the session till now, don't forget to like the session and to subscribe to the channel, and don't forget to press the bell icon so that me or any of the faculties are coming live, you will get notification of the same. And if you haven't checked out MP Civil Judge Prelims crash course, just do check it out. Link is in the description box. मिलते हैं next class में कुछ और नए discussions के साथ. ठीक है, चलिए, take care, bye bye all of you.